Good afternoon, everyone, and welcome to today's event entitled 10 is Too Young: The Developing Brain, Vulnerability, and Criminal Responsibility. My name is Fergal McFerrin, and I'm the Policy and Public Affairs Manager at the Children's Law Centre. I will be facilitating today's event on behalf of the 10 is Too Young Coalition, and we're delighted to be collaborating with the Royal College of Psychiatrists to deliver today's session. I will introduce and hand over to our speaker very shortly, but before I do that, I'd like to briefly mention some logistics for today's session. Throughout the session, you will be able to hear either myself, Dr. Phil Anderson beside me, or a presentation on screen. You won't be able to see other attendees, and all attendees have automatically been muted due to the numbers joining us this afternoon. Your questions and comments are both encouraged and welcome. So as the event gets underway, you'll be able to use the Q&A function to share your thoughts or pose a question. In the time we have following the presentation, I will try to get through as many questions as possible. We are also recording today's event to share afterwards, and so you can expect us to be in touch again in the coming days when it is available to be shared. Which brings me to why we're all here today. The 10 is Too Young Coalition are a group of organisations: the Children's Law Centre, Children in Northern Ireland, NIACRO, Include Youth, the Voice of Young People in Care, and the Northern Ireland Commissioner for Children and Young People. We have, individually and collectively, for many years now, been arguing that our age of criminal responsibility should be raised, and that at 10 years old, Northern Ireland's age is far too young. And today's discussion is happening in a specific context. The Justice Bill currently making its way through the Northern Ireland Assembly presents, in our view, the best possible opportunity to deliver on this long overdue reform. And in our work engaging with politicians and other stakeholders, one of the most significant areas of interest has been in relation to the growing body of evidence regarding our understanding of child and adolescent development and how it should be considered in the context of questions around criminal responsibility. I'm delighted to say that we've clearly picked up correctly on that level of interest, as we've had a significant amount of registrations for today's event from a wide and varied range of stakeholders. And so we hope today proves both interesting and useful to you all. So now to our guest speaker. We're very grateful to the Royal College of Psychiatrists for their engagement on this issue and for agreeing to work with us to deliver today's event. I'm pleased to be joined this afternoon alongside me by Dr. Phil Anderson, who will be presenting to you all on behalf of the college. Dr. Anderson is a consultant forensic psychiatrist who works for the Forensic Child and Adolescent Mental Health Service for Northern Ireland and Acorn Therapeutic Service. The latter provides mental health and enhanced therapeutic care in the regional secure care facilities. He undertakes expert witness work for largely adolescent cases in court proceedings, and alongside many published works, has co-authored a very recently published journal article exploring changes to the age of criminal responsibility internationally. As I hand over to Dr. Anderson, I'd like to remind everyone to use the Q&A function to ask questions or share comments, which I'll monitor and will come to following the presentation. So, Dr. Anderson, thank you for being with us today. Please take it from here.
Thank you. And on behalf of the Royal College of Psychiatrists and myself, I'd really welcome the invitation today to be able to speak about this important topic. So the title of the presentation is 10 is Too Young: The Developing Brain, Vulnerability, and Criminal Responsibility. So what are we going to talk about today? So there's lots going on, I suppose, in this very complex medical, neuroscience, legal issue that has very real impacts across the North. So I think it's important to go through this in a coherent and organised way, setting out the parameters in terms of the definitions. I'm going to preface this with a bit about my personal background, I suppose, in order to demonstrate that this is from a clinical coalface perspective as much as it is based in the developments in neuroscience and legal research. I work in unusual nexus of the two subspecialities of child and adolescent psychiatry, which is the assessment and treatment of mental health and neurodevelopmental conditions in children and adolescents, and forensic psychiatry, which is the assessment and treatment of same within the criminal justice system, that also includes aspects of risk and public safety assessment, and also the expert witness work that I do on a part-time basis in addition to my HSCT role. I have had I was going to say fortunate position, but also with challenges and a privilege, but challenges to have worked across the entire secure estate in the north of Ireland in terms of Shannon Clinic, the regional medium secure hospital, all the 3 adult prison establishments, the 2 regional secure care facilities in terms of Juvenile Justice Centre, and Lakewood Regional Secure Children's Home. I have a background in initially in paediatric medicine, and I've also worked in the top left corner in Broadmoor High Secure Hospital in England to complete my training and become a forensic psychiatry consultant. In terms of my current day jobs, I work for Acorn Therapeutic and Mental Health Service, which provides community CAMHS equivalent care to the Woodlands and Lakewood. I also work for the Forensic Child and Adolescent Mental Health Service for Northern Ireland. So this is a service commissioned across the 5 trusts and for the Youth Justice Agency to support local agencies with young persons who present with complex needs and significant public safety issues. That is where many of the young persons that I work with are currently reside in terms of Woodlands Juvenile Justice Centre, and then to the right, Lakewood Regional Secure Children's Home. As I said at the very, very beginning, I think it's important to set this out, the parameters of definition. To start off with, I'll discuss developmental capacity. So this refers to the evolving ability of a child to make decisions, which is shaped by the ongoing neurodevelopment across several domains, including cognitive, emotional, social, and moral. And the point at which developmental capacity stops being relevant is determined by a set of laws that define legal capacity for either specific decisions or categories of decisions. Legal capacity to extend further is a young person's authority under law to have a particular status, make a particular decision, or engage in particular behaviour. Examples include the lowest age to get married, the lowest age that you're able to vote, and to have full capacity to make medical treatment decisions. However, legal capacity can be restricted on the basis of developmental capacity or mental capacity and the issues of mental health or intellectual disability issues. So coming into criminal responsibility, to be found criminally responsible for or to be convicted of a criminal conviction, someone has to have completed actus reus, which is the guilty act in Latin, and mens rea, which is guilty mind. And with that, minimum age of criminal responsibility is the legally defined minimum wage at which a young person can be considered capable of criminal responsibility and be subject to the criminal justice process. And that means that that lowest minimum age, which in Northern Ireland is 10 years, that means that they are by definition the same as a 25, a 45, or a 55-year-old adult. Some of the background to this. So the UNCRC in 2019, in their general comment 24, came forward and remains to the present that they strongly recommend that a minimum age of criminal responsibility of at least 14 years to nation states. They say that the current states that have ages of MICR of 12 to 13 are not internationally acceptable. And further, they've said that it does not reflect the current scientific understanding of young persons' developmental capacity and leads to premature criminalization. So I am involved in an international forensic adolescent research group. The acronym is GIRAFFE. And we recently had accepted for publication an international comparison of 4 nation states about the minimum age of criminal responsibility. And with that, we looked at the history, systems, current developments in neuroscience, and potential future developments. So it was a good opportunity for Northern Ireland to be included in this, and a link was provided as part of the invitation to this for those in the audience that may want to read this specific paper. This is one of the graphics from it and a chart of where things sit internationally. And I suppose it is not surprise to anyone in the room, like within Western Europe, we have one of the lowest stages of defined minimum age of criminal responsibility. I suppose to provide comment to some of the global patterns that we observed as part of this is that 14 years is the most common minimum age of criminal responsibility. However, globally, it ranges from 7 years to up to 18 years in some Latin American countries. 26 countries vary MACR by offence type, which the UN advises against. Some countries still use dole incapax, which in Latin means incapable of evil, which essentially allows the prosecution between a defined age bracket to prove that the young person was able to form mens rea. 9 countries have different minimum age of criminal responsibilities based on gender, and 13 have no minimum age of criminal responsibility whatsoever. As part of this study, we considered the factors influencing MACR across the globe. I suppose the view of those that contributed to writing it, that is, there's very limited impact of neuroscience and legal research on the determination in law of what in each member state of what the minimum age of criminal responsibility is. However, there are obviously other factors in terms of the standards that are set. There's national history and the law setups in each country as a legacy of colonialism and other factors. There's obviously media pressure and aligned to that, political populism of high-profile cases. There's also cultural expectations and what can be reasonably afforded within GDP and economic circumstances of each country. With that, it's important to also consider the impacts of early criminalisation, which informed the UNCRC's latest position on this issue. Labelling theory and stigma is one aspect. Studies suggest that early justice contact creates stigma. This is formative in shaping identity, and that identity in itself becomes a driver for further offending behaviours. Custodial interventions have been demonstrated in study and observation to potentially reinforce negative peer networks and increase the likelihood of repeat contact with the youth justice system. And there are also life course impacts globally across education, employment, and health outcomes. Some of the evidence from recent MACR reforms have included Scotland, which raised its MACR to 12, of which there's been no serious negative effects in terms of reoffending rates. And interestingly, and to the best of my knowledge, uniquely, Denmark lowered its age from 15 to 14. However, this was associated with significant negative outcomes with respect to increased offending rates, and this was reversed after 2 years. I suppose in consideration in many of the matters that may influence and the problems that arise from a low minimum age of criminal responsibility is where it sits in terms of the minimum age of capacity in law to make other decisions, namely health and social care decisions. This was another publication I was involved with several years ago, looking at the issue, I suppose, in particularly in terms of the new Mental Capacity Act and how children under 16 are sitted with that. But this paper broadly also broadly considered the issue of making health, social, and criminal decision making. And there does seem to be a logical issue with the fact that a young person may not be considered able to make a decision about the contraceptive pill at 14 or other medications, yet are held criminally responsible for offending type behaviors at age 10. And in further context, when important healthcare decisions have to be made or social care, they are invariably provided by professionals in an appropriate environment with literature tailored to the young person's cognitive and developmental and emotional needs, as opposed to offending behavior occurring under the influence of peers, substance misuse, and a background of challenging life circumstances. I suppose another factor that has to be considered in terms of the minimum age of criminal responsibility is the developing brain. For anyone interested in this subject, I strongly recommend this book by Professor Blakemore, Inventing Ourselves. This has incredible, accessible insights into the development of the teenage brain and how that influences how adolescents experience the world and how the rest of the world experiences them. Needless to say, Prof. Blakemore in her book explains very well the changes that have occurred in the scientific understanding of the adolescent brain. Historically, over 30 years ago, it was seen that there was two periods of brain development. There was what was early childhood from infancy, and then there was what was essentially the adult brain. But now what we know is that adolescence in itself is a very discrete and particular period of brain development that has its own opportunities and challenges and structural changes. It's characterized by asynchronous neurodevelopment. The frontal lobes mature in general much faster than the limbic system, which is the frontal lobes being where higher executive functioning occurs, and limbic system being more about reward and emotional processing. To explain this further in the granularity of what occurs, white matter of the brain, which should really be thought about as like the broadband, the connective infrastructure, and grey matter is really like the processing hubs. So grey matter peaks in early adolescence in a process called synaptic pruning process, whilst the white matter, which is again, to reiterate, the higher executive functioning, so that would be to explain further issues of self-regulation, planning, moral reasoning, anticipating consequences, and with that, future orientation. This continues to mature into the early 20s. So that essentially, the push factors in terms of behaviors with respect to brain architecture matures faster than the modulating aspects of the brain architecture. And that's really important when we think about how young persons make decisions and also the behaviors that they may display. These changes are readily visible on MRI, which has been really significant in terms of the understanding of these changes that occur in the adolescent brain. But not only is the changes in grey and white matter visible, it's also the functional activation of these brain regions significantly differs between adolescents and adults when completing the same cognitive tasks. On a positive note, the adolescent brain is recognized as being highly plastic and having relatively more capacity for positive change with therapeutic and other interventions. So I suppose, what does this all mean? So you may say this sounds quite complex, but what does this mean on a practical coalface in our societies or how we interact with our teenagers in the classroom, in our communities? So the functional implications of this, which in essence is heightened emotional reward drive but immature executive function. This leads to preoccupation with peer influence and peer exclusion. It's associated with impulsivity, risk-taking, high reward seeking. There's low future orientation. And also, I think significantly, when we think about the justice system, there's much less influence of moral reasoning compared to these other factors in how adolescents make decisions, particularly at that very early period of adolescence. That also, in functional terms, this is seen in the level of offending, which peaks in adolescence, which is demonstrated on the current graph, and then that tailors out as the maturation process that I explained earlier continues into early adulthood. So I suppose that is a discussion of neurotypical young persons, but actually many of the young persons that are in our youth justice system have a high prevalence of complex needs. Research would indicate that young persons in the youth justice custody and youth justice system would have 3 times the prevalence of mental health conditions as those in the general population. And that this was an FOI a couple of years ago about Woodlands Juvenile Justice Centre to demonstrate this research finding. There is much discussion across the statutory agencies about the impact of adverse childhood experiences and how this has been demonstrated to have a global impact, not just on health, but on mental health and educational outcomes. But this is also not has a significant impact on justice and public safety outcomes. At least 77% of those known to youth justice report 4 or more experience of adverse childhood experiences, according to a recent study by Malvalso. And a UK census found that of 74% of young persons in secure care had been exposed to 4 or more ACEs. Much of the research into the original ACEs study that demonstrated this link between exposure to trauma in early childhood and these global outcomes was in San Diego, but it was followed by probably a much less well-known research study into juvenile offenders in Florida State. It was a huge study, well over 10,000 juvenile offenders, and basically it demonstrated that there was a dose-response relationship between ACEs and the reoffending rates of juvenile offenders. Neurodiversity is also extremely high in youth custody. The rates of autism spectrum condition are a multiple of what it is in the general population. Perhaps one of the highest issues, which I don't think is always well recognized by the state, is the prevalence of speech and language issues, so receptive and expressive language conditions, which some research indicates can be up to 90% of the youth justice population. And also intellectual disability is in around the sort of the quarter mark, which is again is much higher than the general population. So, what does this all mean? What needs to change? What is the effect? UNICEF has spoke to this about what should happen to children under the minimum age of criminal responsibility based on the UNCRC or following rather the UNCRC declaration. They advocate for prevention, community-based interventions, a reorientation of youth offending as a safeguarding and exploitation issue, strong police connections to the welfare system and referral systems and communication, the need for much broader and accessibility in terms of psychosocial assessments, and wider supports in terms of life skills and mentoring. I suppose in terms of my thoughts, the Royal and first of all the agreed position of the Royal College of Psychiatrists, we agreed as members and within the relevant faculties that that 10 was too young and 14 was our agreed position at that time, which continues to present. I suppose the issues that I would focus on, and obviously there are concerns that will come from the public and from other organizations and groupings and individuals about what the potential impact this would have in society in terms of public safety and wider criminality. As with health issues, prevention is better than cure. And I think it's a really important issue in the north of Ireland that we are the only region of the UK that does not have a holistic, multi-agency, cross-departmental public health approach to youth violence, which targets the whole population in terms of school programs and public health messages about knife crime and prevention of knife crime. There's less focus on the populations at risk, so particularly young persons who are excluded at school or experience significant trauma. And I think that's a really important issue that alongside Scotland, Wales and the UK regions, that Northern Ireland has a violence reduction unit that focuses on data-based outcomes and evidence-based approaches for reducing youth offending. For young persons engaged in potentially unsafe behaviours, I think there is the need for an agreed cross-statutory youth agencies approach to enhanced risk management. So that would be all of CAMHS, Youth Justice, social services. And also, there was the review of regional facilities in 2018, and it was observed within this report that there was a need to improve the secure care facilities. And in extremis, where a young person needs to be stabilised within the containment of a secure care environment with the relevant therapeutic and professional supports, it's important that there is the full implementation of that review. Public health approaches, just to speak more to that issue, so that's effective interventions at the earliest point and working with families, and the potential long-term efficiency savings have been estimated at least 70,000 per child of young persons involved in the youth justice system. That is really everything that I need to say. Hopefully that has been helpful in unpacking some of the issues, some of the challenges, and some of the recent developments of this important issue.
Super, thank you, Phil. You covered a lot of ground there and actually made what is quite a complex area quite accessible in many places. Whilst I'd like to take a minute just to invite those online to consider any questions they may have, and we'll come to those in a second. I want to start just to reflect that from your presentation, I'm struck by a couple of things in particular, although I'll have to watch this back, I think, to think about some of the other aspects as well. But I'm struck in particular by Northern Ireland's low wage of criminal responsibility, how much of an outlier we are in that respect. How we also appear to be an outlier when we look at the science that you have very clearly reflected and spoken to today, but also the other overarching point that is concerning to me, and I'm sure to those attending today as well, is the range of vulnerabilities and needs of those children, young people who are engaged in the youth justice system, and whether we are effectively meeting their needs through that system. And there is a kind of a broader question in our work around this issue and others that has been raised quite often about what's the purpose of age limits, and age limits often being used as a protective mechanism. And there's a question for me here about whether having such a low age of criminal responsibility is actually providing protection, or whether it is contrary to that.
Yeah, good question. I mean, the evidence that there is, which informed the general comment from the UNCRC, is that lower ages of criminal responsibility are not associated with improvements in offending rates or public safety issues in terms of the relevant age group of young persons. there's no data that I'm aware of that sa- says that a minimum age of criminal responsibility of 11 or 10 improves the outcomes for our communities.
That's useful. Thank you, Phil. We have started to get some questions in from those joining us online, so I'll start to pose those. And folks, if you do have thoughts or questions or comments, please feel free to use the Q&A function to share those, because we have got a little bit of time now to explore this in a more conversational way, and we really welcome your engagement. I'll start with our first question, which is from Rachel Woods at the Children's Commissioner's Office, who said, "Thank you for your presentation, Phil. There are a number of amendments tabled to the Justice Bill currently making its way through the Assembly, with two of those currently tabled proposing exceptions to a raised age. Do you have any thoughts on exceptions?"
I suppose I would ask what the purpose of the exceptions is. For me personally, it's the child rights perspective is first and foremost, that there has to be equality in terms of the decision about what the minimum age is. And if it's an issue of public safety, that is the concern that is driving that. I've outlined in terms of the aspects that I think have to be addressed within Northern Ireland in terms of a unified approach in terms of risk management with all of the statutory agencies. So there's an agreed enhanced risk management procedure for all agencies.
And it's built on that, there's another question here. To what extent do you think the apparent misalignment between legal thresholds for mental capacity and criminal responsibility reflects a gap between legal standards and contemporary neuroscience on child brain development?
I think it's extremely significant that the reason for the health and social care decisions being set as they are is much closer to what the neuroscience basis for that to be. So there is a legislative disconnect, as it were, between the capacity to make criminal decisions, health and social. And I think as well, contextually, as I explained and referenced in the talk, when young persons make important health or social care decisions, it's often done, or should be done rather, in an appropriate environment with professional supports, with information and explanations tailored appropriate to their developmental and cognitive and emotional needs. Whereas the criminal decision to complete a criminal or offending act occurs often late at night without adult or professional supervision, with the influence of peers and potentially other psychoactive substances, and a context of potential unmet mental health and neurodiversity needs, and difficulties at home and traumatic life experiences. So logically, you could say that that context, that background, when the actual decision is made, would almost press for it to be higher in logical terms. But it's an important question as well.
Thank you. And there's a couple more questions here that I think are very similar. I'm not sure whether we'll be able to answer them directly today, but it might be something you can speak to generally. The questions are asking basically, what are the figures in respect of the number of children who offend between the ages of 10 and 14 compared to those 14 to 18, as well as then a further question that's asking around what are the numbers we're actually talking about here, both in relation to general criminal activity, but also potentially more serious offences. So in your experience, I suppose, what reflections would you have about the level of activity we are actually talking about?
In terms of actual serious issues which would result in the use of youth custody, those numbers are relatively low. The youth justice data about Woodlands is publicly available on the Department of Justice website. So those numbers are, in terms of admissions, are relatively low. In terms of all the different aspects of the various types of offending, from various acquisitive offences, criminal damage, I couldn't speak. I would have to reference uh, resources to be able to speak about those individual things. But actual, in terms of serious issues, that is relatively low.
And we can find that information and share it in the material that we follow up with from today as well, if folks attending would find that useful. I'll just do another call out for anyone who has questions to pop them into the chat while I ask a further one that I want to, based on something that you spoke to in your presentation, where you talked about the impacts of labelling. In the paper that you recently co-authored, I was struck by a particular line which speaks to the point that you made in your presentation as well, that even low intensity impact with the justice system can signal to the child that offending and being a young offender is part of their identity, and thus can increase the risk of recidivism. I wondered if you'd be able to speak to that a little bit more, and about the impact of that on our children and young people.
Yeah, sure. Yes, no, that's a very important issue. I suppose that is highlighted in the research papers I referenced, which are also referenced in the recent publication. I suppose there is the data that's available in terms of the publications, and then that which I've observed directly in terms of the young persons that I've worked with and have been involved in formulations, meaning psychological understandings of what they've been communicating through their the offending or challenging behaviours. Identity is really important in adolescence. I'm sure we can all cast our minds back to the ups and downs and the explorations of that period, and that's fundamentally what it's about understanding the depths of who we are and what we enjoy, what we don't enjoy, the real core issues of where we belong and how we identify. So if you're pushed in a certain direction in terms of a particular identity, that is a real driver in terms of young persons then owning that within different subgroups of identity. It could also lead to exclusion from young persons not involved in offending behaviour, that pushes to more outgroups that are involved in that. So there's like a negative feedback cycle of labelling. That's how I would describe it. And there is the part that if people constantly think that we're going to behave in a certain way, we often will, because that shapes our subconscious and those aspects of ourselves and our inner worlds that we're not totally aware of. And with that, there are the structural changes I referenced earlier that predispose adolescents towards impulsivity, towards sensitivity to peer inclusion or exclusion, and rewards taken behaviours in terms of winning approval from peers, in terms of potentially completing a adventurous offending act of some kind. So to win kudos with their peer group.
I think it's a really important consideration in this conversation. And we have a question here that I think builds quite nicely on some of what you've already spoken about in relation to risk management, that public health approach to violence. Your colleague Thomas McKeever from the Royal College has asked, can the risk management you speak of as being necessary, firstly, be done in parallel to a change to the age of criminal responsibility in your view? And secondly, or does it need to precede any change? Would it be onerous to implement that risk management?
I think the two aspects stand separately and alone in their own importance. I fundamentally, my own personal view is that the minimum age of criminal responsibility needs to be argued first and foremost on children's rights grounds. There has to be in terms of approaching equality for health, social and criminal decision making. But I think as a wider considered approach, cross-departmental approach, I think the need for public health approach is really crucial. We've obviously in the media, the improvements in Scotland in terms of violent offending has been very topical over the last 5 years. And I suppose I would reflect that with a region with a long history of many different types of violence, particularly what's been highlighted this week about domestic violence within the adult population. I'm curious as to why we are the only region that does not have a public health approach to violence. So on that grounds, I think that's really important. It's also understanding that the way that violence presents is not always through the criminal justice system, nor can be dealt with by the criminal justice system. So what I mean by that is that Cardiff University has demonstrated that many violent assaults are not picked up within the justice system and often actually present to health in terms of emergency departments and minor injuries because of their injuries. And that's really important to be able to bring all of the data together to then target evidence-based resources towards the prevention of violence, particularly those who are at risk, which research has demonstrated is if you have those that do conduct violent behaviours have often experienced violent assaults themselves. So if we're able to intervene in that period with targeted resource, by having proper data sets that combines health, criminal justice, and education data on youth violence, I think that would be immeasurably important for Northern Ireland.
And I have a further question here that speaks to some of what we've already covered, and there is a bit of a statement I'm going to read out, so if you need to take a glass of water, this is a good time to do it. My colleague Liam, who runs the Children's Law Centre's advice service, who's watching from downstairs, I think is reflecting some of what we see in some of our casework that we receive here through our free advice service, where he said, having such a low age of criminal responsibility means that the PSNI become part of the matrix for dealing with children who have complex needs from the age of 10. This is wholly inappropriate, but is something that is increasingly a very real issue and a real challenge. This impacts on limited PSNI resources, and due to limited social care capacity, it is the PSNI that are often left to deal with complicated care situations. This aspect is not raised often enough. Just as with mental health crisis in adulthood, the police are not equipped to deal with these situations. Raising the age would lift these very young children with vulnerable needs out of these types of inappropriate responses. Do you have thoughts?
Yes. I mean, the police, I suppose, will always have broader responsibilities about ensuring safety in our communities. But there is no doubt, and I suppose there may be people from the PSNI in the audience, but I would imagine that the amount of operational time that this could take up is significant. And ultimately, it does come back to this public health understanding of youth offending. The roots of why young persons offend is the same as why often they develop mental health conditions, why they struggle with education outcomes, why they've difficult global health outcomes, which is it's the global impact of having traumatic early life experiences and not enough nurture and positive good life experiences in terms of nurturing, supportive, attuned relationships. And that's in our societies and communities, that really is the core public health issue that needs to be addressed for mental health, for education, and for public safety, youth justice.
And building on that, I think it's linked to some of what you presented, but also some of what's in the paper that we've referenced a couple of times now. A query over what, in your experience, are the most common misconceptions about the minimum age of criminal responsibility that you encounter, and how does the clinical evidence about child development challenge those assumptions?
Well, I suspect from popular press and comments and made in public that this is an issue of moral equivalence in terms of moral reasoning, determining what is right and what is wrong, and whether someone has a guilty mind for the offence. I hope that I've went some way in demonstrating that moral reasoning does not influence the adolescent brain in the way that it would in a neurotypical adult. And it doesn't really translate in terms of that low age of responsibility in terms of ensuring moral good, which I think I suspect is what is a view that is held in the public. I suppose it would be helpful, for someone to articulate that view, because I suppose it isn't mine, to be able to have that in conversation. But yeah, that would be my thoughts about it as such.
We have a question here, and thank you everyone there coming in thick and fast now. A final options paper is due on the development of a Barnhouse model to the Ministers of Justice and Health. Would be interested to know your views, Phil, on the benefits of this much more joined up approach across departments and agencies, but also whether this would potentially be a missed opportunity if a child-friendly multidisciplinary environment is provided in terms of the youth justice system without a change to MACR.
As much as I would support the Barnhouse approach in terms of that, I read it. I mean, it has a lot of face validity. I suppose I don't have direct experience of working in that as such, which is commissioned in other European countries. But I don't see it as an alternative for a minimum age of criminal responsibility, because again, that my main reason for that is child rights, but then it's also consideration of the neuroscience and the complex needs of the typical youth justice populations.
Dr. Brennan here has asked, there are slight average differences in neurodevelopment of boys and girls. Is this one of the factors which suggests that age 10 is an age where neurodevelopment is still happening, especially in boys?
Could I ask you to repeat that question,
Yeah.
Fergal?
There are slight average differences in neurodevelopment of boys and girls. Is this one of the factors which suggests that the age of 10 is an age where neurodevelopment is still happening, especially in boys?
I suppose I can't speak to with precision about the gender differences. Certainly, those countries in our study that have different minimum age of criminal responsibilities would also have different approaches to gender-based issues in terms of equality that way. So it may be part of culture within said societies. I think I think it's been largely covered about the neurodevelopmental changes and why that increasingly makes the current minimum age of criminal responsibility untenable, and has led to the UNCRC making its statement in 2019.
Which brings me to our next question. In respect of adverse childhood experiences and statutory involvement, is there a working agreement with social services, forensic CAMHS, in order to address childhood trauma, in order to prevent offending for those children who may be subject to child protection plans or child looked after plans?
Yeah, being trauma informed and neurodiversity aware are really key aspects to working in any forensic CAMHS service, not just our own. And I suppose it's really fundamental. Young persons who are present with problematic behaviours or offending behaviours, it's often a communication of an unmet need. They might not be aware of it or not, but often it's those things of identity, safety, purpose, connection, all those things as human beings, as humanity, we fundamentally require. So being able to make sense of that is really key for ourselves and our partner agencies in social services, youth justice, other CAMHS service and intellectual disability services. Is what is that child communicating? How does this relate to their difficult experiences or absence of positive, nurturing childhood experiences? So being trauma informed and being aware of the appropriate therapeutic interventions, and also to be sequenced in the appropriate time as well, according to the child need, is really crucial. And that's certainly something as in my profession really aspire to, and is critically important.
Thanks, Phil. And a question here from Natalie Wheelahan at Children Northern Ireland, who's asked, in the context of your work, do you have any reflections you could share about the longer term public health outcomes which have come about as a result of raising the minimum age of criminal responsibility in other jurisdictions?
It's difficult to comment on that. I suppose those longer term public health issues, you know, for example, Scotland has relatively recently increased theirs to 2012. And those more immediate issues of youth reoffending rates have not significantly increased according to the current understanding and available data. Similarly, in Denmark, the opposite happened in terms of the reduction of the minimum age of criminal responsibility that was reversed after 2 years. But it's very difficult to say in terms of longer term outcomes, and that is something that will need longitudinal studies about the comparison of countries with a high MACR versus those with lower ones, unfortunately, like ourselves. But it's an important question, an important research question.
And we'll take, I think, maybe two more questions before wrapping up. There's a question here asking if you could reflect more on what you talked about in your presentation in relation to the work in Denmark, where the age was reduced and then brought back up. Maybe just speak a little bit again about that, if you could.
In terms of
just what the initial findings were and why the age was raised again.
The reoffending rates, largely what was referenced was the reasons about how early criminalisation actually promotes reoffending. That is the current working understanding of persons there in the relevant statutory agencies about why the rates of reoffending and other negative outcomes increased. Certainly, it's referenced in the paper that I was a co-author in, but we certainly can provide further information about that if needed. But I think it's the only time that I'm aware that this has happened in terms of a reversal. So I think the data, as it were, from that, granted limited to one country with perhaps particular specific context there. I think it's important nonetheless to be considered as part of a wider data set which underpins the reasons for consideration of change of the minimum age of criminal responsibility here in Northern Ireland.
And we'll take our final question now, which is from my colleague Dr. Paula Rogers at Include Youth, who asks, what message would Phil have for elected representatives who may, through their reaction to amendments to the Justice Bill, have an opportunity to finally bring about change?
10 is too young, to say it simply, is the title. From a child rights perspective, from a neurodevelopmental perspective, and a humanity perspective in terms of consideration of the complex needs that are so high in our youth justice population, that those matters should be influencing your decision making rather than archaic understandings of moral development and moral reasoning that isn't underpinned by our current neuroscience. But also, I think the public health message is really important in terms of youth offending being seen as a consequence of exposure to adverse childhood experiences. And it's really important that the executive considers that Northern Ireland needs a violence reduction unit like England, Scotland, and the other UK regions to provide evidence-based and data-driven approaches to the prevention of youth offending.
Thank you, Phil. I think you've provided a lot of food for thought today. I think it's been a very timely conversation. because of the opportunity that is in front of us in terms of the passage of the Justice Bill. I want to thank you and the Royal College of Psychiatry for being part of today's event, for agreeing to participate today. I'd also like to thank all of you who have joined us online, who have engaged and asked questions. We will be making the recording of today's event available, and you can expect us to be in touch in the coming days and weeks. And it's important, I think, just to underscore once more that the age of criminal responsibility in Northern Ireland is currently 10 years old. Recommendations suggesting that and endorsing that the age should be raised have been around for quite some time. The Youth Justice Review in 2011 made recommendations of this nature. We are now over a decade on and are still waiting for the age to be raised. We have a real opportunity in front of us to do so. We believe it is in the best interests of our children and young people that it happens, and we will continue to advocate for that case. So thank you all so much for joining us this afternoon, and we'll be in touch with further material, and please do continue to engage with us as we head towards the next stage of the Justice Bill in the Northern Ireland Assembly. Thanks.